Hi, are you ready to take the next step in your immigration journey? Let's get started. I will talk to you about employment-based green card application, or what is commonly known as PERM today. My name is Remzi Kulen. I'm an immigration attorney with decades of experience in immigration law. I have helped thousands of individuals and companies obtain permanent residency in the United States. Today, I will try to explain you how a US employer can sponsor an employee and get a green card. My goal is to help you understand how this whole process works and the timeline that is required to complete this application successfully. As you may know, there are different ways of getting a green card in the United States. One of them is employer sponsorship. The process is usually called PERM because the first stage of the application, which is actually a labor certification that is approved by Department of Labor, is called PERM. Although the whole application process seems a little bit complex and there are a lot of different applications and waiting periods, the success rate in these applications are very high. Particularly in our office, we have a success rate of 95 to 98% in these applications. So although it looks like a complex application and it also takes a lot of time, I recommend my clients to apply for PERM if they can. So although it looks like a complex application and it takes a long time, with the right guidance and strategy, you can get your case approved. So I generally recommend my clients to go with the PERM application if they find the chance to do it. So the key concepts in this application are: there must be a bona fide job offered by a US employer. So there must be a bona fide job offer and there must be a US employer. There must be a foreign employee who is willing to take this position, and the US labor market must be tested. There are no willing or qualified US citizens or green card holders who applied for this position. So then the key questions are: who can apply for the green card? Who can be eligible for it as an employee? What does the procedure look like, and how long does it take to complete this process? Let's talk about the US employer who is offering the position first. The US employer is usually a legal entity. So if the employer is a legal entity, it could be an LLC or it could be an incorporation. The owners of the company don't need to be US citizens or green card holders. On the other hand, if you're sponsoring someone as an individual, then the individual must be a green card holder or a US citizen. Secondly, there must be an open position in the company. The requirement about the job opportunity is that this has to be a bona fide position. What does that mean? It means that this job position must be available in this company in the foreseeable period. Don't forget, it doesn't have to be an immediate position, but it has to be an open position that can be performed in the company in the near future. And finally, the US labor must be tested, meaning you need to advertise the position in the required media channels to make sure that there are no willing and able green card holders or US citizens who are qualified for the position. When these conditions are met, an application can be filed and it's called PERM. So what are the steps to file such an application? So before you even start the process, the thing that we analyze is whether this application can be successful if we go forward. And the way to do it is try to get to know the company a little bit, the positions in the company, and what kind of a position they can offer to the employee, and whether this whole thing will be successful in the long run. We look at the finances of the company, number of workers at the company. We also take a look at the gross income of the company, net income, and also the assets. The fact that a company is newly established or is not making a lot of money, or the fact that it doesn't employ a lot of employees, do not mean that these companies cannot file for green card applications. This is almost like a puzzle. You need to make sure that the company, the position, and the employee align so well that this application could be successful in the long run. Generally, companies who are established at 1 or 2 employees would be good candidates for this application. But again, we need to analyze the finances, the positions, and the company, and also the employee and his or her background to see if this application has a chance of success. And we do all of this before we start the application. I think that's one of the reasons why we have such a success rate with these applications. We have to see that this application has a high likelihood of success. What are the steps in the employment-based green card application? The first step is PERM application or labor certification. This step is controlled and managed by Department of Labor. Basically, in this first step, you first analyze the job description of the company and whether this job description and requirements are in line with Department of Labor requirements. Secondly, you need to figure out if the company will be able to show its ability to pay for this position. This is a technical term. Basically, the net income and the net assets of the company going forward must be adequate to sponsor this worker and its salary and his or her salary. Thirdly, you need to make sure that the employee is qualified for the position. Once you have job description and the requirements aligned, you then file a prevailing wage determination with the Department of Labor. This is actually what initiates your requirement for prevailing wage determination from the Department of Labor. What you're asking with this application is, we have a position open, it's in this geographical location, it's for this company. Please let us know what the salary would be for this position. The Department of Labor takes a long time to adjudicate these applications. Currently, the time to adjudicate these applications is anywhere between 6 months to 12 months. Once you have the salary, what you need to do is conduct a recruitment campaign for this position. This recruitment campaign is a very structured recruitment process. The Department of Labor requires for the employer to advertise positions in certain places. These include in-house postings, newspaper ads, ads with the Department of Labor's website, and also some additional recruitment steps for professional positions. The recruitment steps usually takes about a month, and then there's a 30-day waiting period in which you receive the resumes and you respond to them. So you cannot file the application before the 30-day silent period. Once you have the prevailing wage determination and recruitment and the 30-day mandatory waiting period, you are now ready to file your PERM application. The PERM application is filed online. If the application is approved, we call this certification. If the application is certified, you can move on to the next stage. But the application can get an audit or an RFI, request for information. This is Department of Labor's way of making sure all the applications are consistent, they are being filed with the required documentation. Because when you initially file the PERM application, it's just an online application. You do not add any documents. If the Department of Labor certifies the application, if the Department of Labor would like to have more information about the application, then they send an audit or a request for information. That's where you are given 30 days to respond to the Department of Labor audit or request for information and provide additional documentation required. Why do cases get audits or RFIs? There might be some triggers to get this, for example, a foreign language requirement or a familiar relationship with the owner of the company and the beneficiary for which the application is being filed, or your requirements for the position may be exceeding the Department of Labor requirements for this position. Those are the general audit triggers. But you may also get an audit randomly. That's what's called random audit. So you don't really know whether an application is going to get an audit or not, but if you do, you have 30 days to respond, and Department of Labor takes 4 to 8 months to review these audits and request for information responses. Once the application is certified, you can move on to the next stage. The next stage is called an I-140 application based on the number of the form that we're filing with USCIS. Based on the name of the form, we are filing with USCIS. Now we are completely done with the Department of Labor phase and we are moving on to the USCIS. The I-140 application is filed by the employer and you need to prove 2 things. The first thing is the company has the financial ability to pay the salary for the position. And the second thing you need to prove is if the job requires education and experience, the beneficiary has them and is qualified for the position. Let's not forget, if you filed a PERM application for somebody, that application belongs to that specific person. And if you want to change, you cannot change the beneficiary in the application. So in the I-140 stage, what you're proving is the financial ability of the company and that the beneficiary has the required education and experience. The timeline for the I-140 application is 4 to 8 months. And this can be filed as premium processing. If you file it with premium processing, the processing time is 15 business days. The third stage of the application is called 485 adjustment of status or consular processing, depending on whether you are in the US or you're waiting outside of US for your green card. Let's say you are in the United States in a non-immigrant visa status and you have a PERM application approved. You can file your 485 within the US as long as you are maintaining your status. This 485 application belongs to the beneficiary. It's not the company's application, it's the beneficiary's application requesting USCIS to convert them from their non-immigrant status to the green card or permanent residency status. It is important to note that in order to be able to file the 485 application, the visa numbers in your visa category must be available. And this brings us to the visa bulletin and different visa categories. Let me talk briefly about them. If the job requires at a minimum a master's degree or a bachelor degree plus 5 years of experience, this is classified as EB2. If the job requires anything less than that, it's called EB3. So EB3 positions are either professional or skilled, where you require at least a university degree or at least 2 years of experience. Anything below that is called EB3 unskilled. Let's say a job requires 1 year of experience or no experience, then it is EB3 unskilled. So depending on whether your job requirement is EB2, EB3 skilled, or EB3 unskilled, you will have a different visa availability according to the visa bulletin. Why? Because every category has a certain number of green cards that can be issued every year. If the green cards are exhausted during that year, you need to wait for the visa numbers to be available so that you can file the I-485 application. It is important to note that if the visa numbers are available in your category, you can file both the I-140 and 485 concurrently with the Immigration Service. So I-140 and 485, which is adjustment of status, can be filed concurrently when and if and when the visa numbers are available. It is also important to note that up until you file the 485, you need to maintain your non-immigrant status in the United States. In other words, filing a PERM application, filing an I-140 application never gives you status. You need to file the 485 and you need to maintain your non-immigrant status up until you file the 485 application. What do you need to submit when you file a 485 application? You need to submit all of your maintenance of status documents. If you are an F1 point, you need to submit your I-20s. If you are an H-1B, you need to submit your payroll records. If you were in another status, let's say E2, you need to make sure you submit all the documents showing that you're maintaining your status. You need to submit a medical report with your I-485 application and any other personal documents that is required, such as birth certificates, a marriage certificate, birth certificates, marriage certificate, etc. The processing time for the 485 application is anywhere between 8 months to 16 months. There usually is no interview with USCIS in the employment-based applications, but USCIS may want to interview you randomly or because of something they see in the application, such as a criminal background. The alternative to filing an adjustment of status is consular processing when people are waiting for their green card outside of the US. In this instance, once the I-140 is approved by USCIS, they send the case to NVC. USCIS sends the case to NVC, National Visa Center, which is that intermediate agency between USCIS and the consulate abroad, and their job is to collect the fees and documents from you for your consulate interview. Once the NVC receives the file, they send you an email asking for you to pay the fees and also submit the documentation on their online portal. Once you submit the fees and the online documentation, they will then wait for the consulate to open up an interview space and invite you for a consulate interview. Again, they need to make sure that the visa numbers are available in your category before being able to forward your case to the consulate and before the consulate gives you an appointment date. As opposed to adjustment of status, if you selected consular processing, there definitely is going to be an interview with you about the green card application. This is how the consulates or embassies give out the green cards. They need to interview you. This interview takes place at the consulate and they ask you questions such as who's offering you this job, how were you made aware of the job, how did you interview for the job, what is the requirement for the job, how you can be qualified for the job. So it usually is not a very difficult interview, but they want to know the basics about this job opportunity and your qualifications for it. There's a few frequently asked questions about this application, so let me go through them one by one. For example, can the spouse and children get the green card together with the foreign worker? The answer is always yes. The spouse and children under 21 years of age can be added to the application at the third stage, which is 485 adjustment of status application in the US, or if you're preferring the consular processing, you can add your family at the NVC stage or at the consular stage before you obtain the green card. What about work authorization and employment authorization? Work authorization and employment authorization are interim benefits that can be filed with the 485 application, adjustment of status, within the US. So if you're on the third stage and filing a 485, you can file an employment authorization and an advanced parole travel permit for you and your family. But if you are outside of the US and you're waiting and you opted for a consular processing, there is no employment authorization or advanced parole. You just need to get the green card and travel to the US with that. How long does it take to get an employment authorization or an advanced parole? Employment authorization takes about 3 to 5 months. Advanced parole takes longer, 8 to 12 months usually. And sometimes when the visa numbers are available, you get the green card even before the advanced parole. This is possible. But the idea of giving you an employment authorization and advanced parole is because the green card is taking longer. They want to make sure that you can work and travel at the same time. Another frequently asked question is, do I need to be working for the green card sponsoring company while the application is pending? And the answer is no. Don't forget, you can start this process and finish it while you are outside of the US. So there is no requirement that you work for this company. Even when you are in the US and you have an H-1B visa or an E2 visa, or if you are in a student status, there is no requirement that you work for this company while the application is pending. The requirement is that once you get the green card, you work at this company for this position for a reasonable period of time. Another question we need to answer is, once a company filed a PERM application for me, can I stay in the United States based on this PERM application? And the answer is no. PERM application and I-140 application do not give you the right to stay in the United States because they don't grant status. What grants status is the 485 application. So up until you are eligible to file the 485, you need to maintain your status in the United States. What if you did not maintain your status? There may be ways for you to file the PERM application and seek for consular processing. For these issues, you need to contact us and we need to find what the best strategy for you would be. And in some rare instances, sometimes the law allows you to file for the 485 after a maximum of 180 days of legal status violation. So in some rare instances where the status violation is less than 180 days, you will still be able to file your 485 application within the US. These are complicated scenarios and it needs a good legal strategy. If you're thinking about filing a PERM application for your employee, or if you're an employee and an employer would like to file a PERM application for you, and if you have any questions, I hope this video will be helpful for you to understand the basic principles and the timeline for the PERM application. It looks like a long procedure. I always thought that this application looks a lot like the chess game, where you make a move and the government makes a move and you only have a limited time. So it looks like a chess game to me, but as long as you have a good strategy, the success rate of this application is 95 to 98% in our office throughout the years. We've helped thousands of individuals and companies get their green cards this way. So if you have any questions about this, please share with me in the comments section. I'd like to do a second video. I would like to talk a little bit more about the application process and any questions that you may have about this application. So it could be a Q&A session maybe where I collect all of your questions in the comment section and provide a Q&A session in my next video. I hope this video was helpful. For more information and the latest updates on immigration law, please like the video and subscribe to my channel. I also have an Instagram page where I talk about immigration developments. Please follow that page as well. I hope to see you in my next video. Take care.